Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a fabulous webinar conducted by Patrick Edgerton. He is an expert in construction lien law and in the state of Illinois. And today's topic is our issues to consider when signing and providing waivers of releases. Waivers of liens, contractor statements, and release of mechanics liens. So without further ado, I'd like to introduce the fabulous Patrick.
Hello, everyone. I would like to thank everyone for coming, and then I am honored to be here. I'm always honored when I give seminars. I do give quite a few, mostly to lawyers and judges. So it's always interesting to give it to the actual end users because they need to always learn at least the concepts because it helps them understand when they do talk to lawyers when these things come up. So obviously, they talked about one thing they want in a release, but I couldn't come up with one thing. And when I give these seminars, I'm talking about waivers. Usually the concepts of waivers versus contractor statements and release of mechanics liens come into play. So a lot of contractors, I'm only allowed 20 minutes. We have a lot to go through, so I can't give too much detail, but usually in this forum, I'm talking to people who are already somewhat experienced. So they kind of know the difference. But let's just kind of dive in there. First of all, we have the waivers, partial and full waivers. A partial waiver. Now, keep in mind that a partial waiver, you have to be careful. You're basically under oath saying that as of the date you sign this waiver, you are owed an X amount of money and there's still a balance due. The problem is, as you know in your industry, is many times a partial waiver has more to do with the waiver of lien for what's available for payment that day. And it's usually you've done substantially more work than what you've listed in your partial waiver. So at one point, lenders were having some fun with this, trying to argue that if you signed a lien waiver saying you were on today's date, that you were owed $15,000 and you did $15,000 because that's what the title company said was due and owing. Let's say something happened, you did no work after that. But even though on the date you signed that waiver, you really owed $30,000. They were arguing that, well, you under oath said that you only owed $15,000 as of that date, and you're only entitled to $15,000. And generally speaking, there's a lot of cases out there. We had to argue it quite a bit for a while that it's a way that in your industry, you generally treat it as a waiver of lien for what's available for payment. One way to avoid that, and I've been telling clients, is backdate it. If you're really owed $30,000 today, but the title company says, well, we have $15,000 for you, backdate it to a date where you were owed approximately $15,000. That way, if something goes wrong, you don't have a sworn statement basically saying that as of today's date, you're only owed $15,000 when you really owed $30,000. So that is something that I recommend doing, and it doesn't come up as often anymore because the lenders gave up. We defeated it, not just me, but other lawyers as well, defeated them on that quite a bit. And there is some case law on there that helps you, but it's better to avoid the fight. It's an expensive fight to fight that issue. Second, full waiver. So full waiver is waiving all lien rights. Be careful of unscrupulous general contractors taking the money. As you know, as a subcontractor, sometimes you give a full waiver, then they use that to get the money from the owner, and then they abscond with the money. So keep that in mind. You can require a joint check or indicate only effective upon payment to help do it. There is a section under the Mechanics Lien Act that failure of a contractor to turn over the money to the sub is a violation of the act, and that under 21.01, it talks about, and then 21.02, which is here, it talks about basically it's a class A misdemeanor if they take the money and keep it. However, I've never once seen the state's attorney's office go after a general contractor for doing this. I have argued successfully that under combining 21.01 and 21.02, that because it's held in trust, if the general contractor absconds with it, and they breach that trust, that they're individually liable now for at least the amount they absconded with. Not maybe the full amount you're owed, but at least that amount, which, as you know, sometimes companies, either subs or owners or general contractors, if they're a corporation or LLC, go out of business and you can't pierce the corporate veil or anything like that, and you're stuck with a company that has no money to pay. Well, if they abscond, you have an argument to go after them individually because they violated the funds. I have done this a few times, and it has worked, but it's usually a heavy battle. They don't like to roll over too quickly when you start going after them individually. So it's an expensive battle. So try to avoid that the issue regularly if you can. Next, The contractor statement. Now sometimes people confuse waiver with contractor statement. The waiver is just waiving the lien. The contractor statement, if you've seen them at the title company, Chicago Title has the common one, where there's a form where the top part's the waiver, the bottom part's the contractor statement, or you just have a contractor statement. The contractor statement is a general or a sub, or even a sub listing under oath their contract amount, their subcontractors or sub-subcontractors, the amount that's been previously paid, the amount of this payment, and the balance to become due. Keep in mind, those are important under the Mechanics Lien Act, because under Section 5, an owner can demand that you provide a contractor statement. And if you don't provide a sworn contractor statement, and then you try to foreclose a mechanics lien, you will be dismissed out. And I have successfully done that. In fact, when you look at this next screen, that leading case, Wider Homes versus Cams, is a second district case. That is my case. And basically, someone refused to provide a sworn contractor statement, and the court knocked out the Mechanics Lien Act. Now, you are still allowed to have a contract action and quantum meruit. So if you don't provide it and you file suit and you get dismissed out, you can still proceed on your contract action and your quantum meruit claim, which generally isn't bad if you can do that. It's just, as you know, a mechanics lien carries more teeth than just a contract action. Remember, I don't want to get into too much detail, but in essence, a mechanics lien is a non-consensual mortgage against the property by the general contractor or the subcontractors. So keep that in mind. Now, people always forget about the next section, Section 22. Section 5 has to do with making a demand, the homeowner, or not homeowner, but a property owner maybe as well, making a demand on the contractor to provide a sworn contractor statement. Section 22 also has that requirement where you can, an owner or general even, can demand from a subcontractor to provide a subcontractor's sworn statement. And if they don't, they likewise would be barred from proceeding under Mechanics Lien Act. For some reason, this doesn't come up much in the litigation. I don't know why. Maybe because of the general is out, the sub is out too. I'm not sure. But people have to keep in mind that you can make the demand on a subcontractor as well if you have maybe a shifty subcontractor out there who's not cooperating and there's a battle of the amounts due and owing, and you just need them to commit. As a general, they talk about, as we all know, there's these extras that people don't get signed change orders quite regularly in the industry. You sometimes need someone to commit as to what they are claiming under oath, what's due and owing. Maybe you disagree, but at least they commit under oath, and that can help quite a bit. So next, this is the part that surprised me. Possession of a lien waiver from a general contractor is prima facie evidence of a defense to a mechanics lien claim. This is ironically my case as well in the first district. What was odd is the owner did not have to even prove that they paid out on the lien waiver or the subcontractor statement, just that they had one, which that is a change in the law. Usually the owner has to prove a reasonable reliance on the waiver that they paid out. In my opinion, possession is not enough, but if you get a motion to dismiss claiming that they possess a lien waiver, you can do what they call a 191 affidavit to say you need to find evidence of when they paid, because you have to rely on the lien waiver as a general contractor. As an owner, to defend yourself from a lien claim. Keep in mind that what sometimes happens is a general gives a contractor's affidavit to an owner, and the owner pays out on it in good faith. Then a sub serves a subcontractor notice. If the contractor statement shows zero amount due and owing to the sub and zero balance due to the sub, you know how there's like several columns, those are the last two columns of a traditional contractor statement, then the subcontractor would be out. But if, let's say, a owner gets a contractor statement listing the subcontractor as nothing due and owing, but then gets a subcontractor's notice from a subcontractor, then pays out, that's a wrongful payment. Now, if they paid out in good faith before receipt of the subcontractor's notice in good faith reliance on a sworn contractor statement, that would be a valid defense to a mechanics lien case. It can be tricky. So we'll get to that in a little bit more, but Lazar was kind of an unusual decision. I won't deny that, but there are ways around it to force an owner to prove when they paid out. The fact that they have a contractor statement dated today doesn't mean they paid today. It could be they paid 60 days from today or even 6 months. Now, keep in mind, so we have three forms that sometimes come up when clients call me. One is obviously the waiver or partial waiver. Two is the contractor statement, and three is the release of mechanics liens. The release of mechanics lien only comes into play if someone perfected the lien. I sometimes get a call from an owner or from a client saying, well, the other side wants to release a mechanics lien. And before they pay me, I go, well, did you perfect one? They're like, no. And I explained to them, well, you can't really release something that's not there. So basically what they need is the final waiver and the contractor statement showing nothing due and owing to any subs. And that is what should be, that is what an owner should require if there's been no perfection of a mechanics lien. And remember, even though it's beyond the scope of today, I think 2 seminars ago I gave it, to perfect the mechanics lien, as a general contractor, you have to record the claim for lien, verified, within 4 months of the last date you did substantial work. The subcontractor has to serve their subcontractor's notice within 90 days on the owner and financial institution, the mortgage companies, within 90 days of the last date they did substantial work. And then also record a verified claim for lien within 4 months of the last day did substantial work. But unless that's been done, there's no reason for a release. I have had some owners still insist on one, so we provide it, we just leave it blank. I mean, why battle with them, tell them they don't need it? You can always prepare one and basically say there's none recorded. I did have one owner that insisted on it, so I prepared the client and gave it to them and said it's not necessary, but if they want it, here it is. So, and they paid out, it made them happy. I'm a big believer on picking my battles. If they want a document they don't need, but it doesn't hurt my client, I just give it to them. Next, there is language that has to be on the release of mechanics lien. According to 635C, there's language for the protection of the owner of this release shall be filed with the recorder of deeds or the register of titles in whose office the mortgage or deed of trust was filed. I see a lot of people's releases don't include that, but that's supposed to be in there, so keep that in mind. So now, other important considerations. This is where it gets tricky. Let's say you're a subcontractor and you don't serve your subcontractors notice within 90 days. But you guys know that when you're doing a small job, many times there's not a construction escrow or there's not a lot of procedures regarding contractor statements. But we all know if there's a big commercial job, there's many times a construction escrow where the title company requires a sworn contractor statement from the general to the owner. Well, a subcontractor is technically perfected for the amount that's listed in a subcontractor statement, as especially the last 2 columns, the amount due this payment, if it hasn't actually been paid yet, and the balance due. This is important because I get clients come in, they're beyond the time. If I ask certain questions of my client, and it sounds like it's a very well-planned demand for contractor statement, and they can at least give me a copy of one of the contractor statements that might be prior, we will sometimes plead upon best information and belief and allege that there's a contractor statement listing amounts due and owing, and then do discovery and find out that they do have lien rights. Now, even if a subcontractor claims 100,000 is due and owing, but they didn't serve properly, their subcontractor's notice, but the contractor statement claims only 50,000 is listed as due and owing, they will be limited to that amount. But it is important to know that there's a lot of, as I tell people, what separates from the men from the boys and the women from the girls regarding the Mechanics Lien Act is not only knowing the general rules, but all the exceptions to the general rules, and then the exceptions to the exceptions to the general rules. We all know the Mechanics Lien Act can be a little complicated. So basically, if a subcontractor does not exercise the right to perfect, they might be perfected. But subcontractors, don't count on it. Generals sometimes think lower amounts than you do. If you really are owed substantial amounts, serve your subcontractors notice. Don't rely on the general contractor to do it. Next, let's see here. Oh, this is the part where under section 24, these 2 sections, you can serve your subcontractors notice on within 90 days of completion date. My outlines are pretty thorough as to giving you information, so I do include quite a bit in the PowerPoint. In essence, what Ariella did in her company was I took my outline and broke it up into a PowerPoint. So there's a lot of detail here. The part that I wanted to show you is that looks like it didn't make it in here, but right in section 24, where it talks about you have 90 days to serve the subcontractor's notice, in there that says, and such notice shall not be necessary when the sworn statement of the contractor or subcontractor provide for herein shall serve and give the owner notice of the amount due and to become due. So it is right in the act. So keep that in mind. It has saved my clients on more than one occasion. Also, there's this the weather type case is a very famous case under section 24 and 21. where the university, in essence, paid the general contractor. They demanded a sworn statement, but they didn't actually look at it. They actually listed amounts due and owing to the sub, and they didn't require or demand any waiver from the sub or sworn contractor statement for the sub, or even pay out to the sub, and they just paid the general. And they tried to argue that because they had a sworn contractor statement that they didn't have to pay out again. Well, that was just the opposite. They had a sworn contractor statement listing the amounts due and owing, and they had to pay twice. So just demanding is not enough. Owners actually have to look at it and then understand it and recognize that those last two columns show anything due and owing to a subcontractor or even a general. The owner has to provide for payouts to those subcontractors. But the Weathertight case was an Illinois Supreme Court case. It's not even that old, 2009. And the owner, the university, had to pay out twice, and it was substantial amounts too. I don't remember the amounts, but it was substantial. So keep that in mind. It's an important factor when you're dealing with contractor statements. Then this is the law that talks about how under section 32, no payments to the contractor or other consideration is valid unless they do it right, meaning demand a section 5 contractor statement or a payout, or a final waiver from a contractor or the subcontractor. We have a situation where both parties can be right. You actually have a situation where the owner did everything right and the subcontractor did everything right. The owner, they demanded a section 5 contractor statement from the general. The general gives it, sworn under oath that no subs are money due and owing, that they've been paid. The owner pays out in good faith on reliance on that sworn contractor statement. Then the subcontractor, after the payout, serves the subcontractor's notice on the owner. And then within 90 days, of course, and then also perfects a claim for lien within 4 months of the last date they did substantial work. You now have an owner and a subcontractor who have done everything right under the act. The courts had to decide who wins when you have both who've done everything proper under the act. They basically said owner wins. Innocent owner wins. Why they did that, I don't know. There's other fact patterns where they go the other way. But in this situation, the owner wins. So keep that in mind. So if you think as a subcontractor there might be an issue, serve that subcontractor's notice as soon as possible and everything. So now there's law in there about how when there's if you are serving a subcontractor's notice and you are a subcontractor, and let's say you claim there's a further amount due and owing, but remember, a general does not know about subcontractors, generally speaking. If you don't perfect properly and what have you, or even if you do, many times you'll be limited to the amount due and owing your immediate contractor. That'd be the subcontractor. As we traditionally know, there's the general contractor, a sub, which would be an electrical contractor, and then the material provider for the sub would be the subcontractor. But if there's only amount due and owing to the sub, and the sub disagrees, but there's sworn statements indicating otherwise, they will generally be limited to the amount due and owing to their immediate contractor. So that can be a problem if there's a dispute amongst all the general and the sub, or the owner, the general, and the sub. Many times the subcontractors do lose out. So I know I'm only allowed 20 minutes. I try to cover through a lot of this. I am more than happy to answer questions if there are. I'm not sure how that works. If there's a chat function, I can't remember.
There is indeed a chat box, and so far no one has asked any questions.
And that I'm more than happy to stick around if people do have questions. I don't know if they can bring up their audio or their video. Ariella, do you know that, if they can do that?
They actually can't right now. All the questions will be asked in a box to the right. And I do want to bring up maybe on the next slide, if you could show them our contact information. Yes. One of the most important things that Patrick went over is if you are a SunRay customer, the statutory language that he's speaking of is actually found in the forms that SunRay has online for the waivers and releases. And you can use, if you utilize our system, you will certainly have access to those forms for free. Everyone who's on this webinar, I know there's a tremendous amount of information that we went over rapidly, but we will be sending out this webinar to all of the attendees so you could watch it, go back at your own leisure, look at the statutes, and take any of the legal processes that Patrick went over and implement them in your day-to-day business. But Patrick, as always, you did a sensational job. Want to thank you again. And if anyone has any questions, our contact details are below, and we are happy to answer any of those questions for you.
And I'm honored to be here again, and thank you everyone for attending. Thank you, Ms. Ariella.
Thank you so much, Patrick.